Prime Minister Mark Carney will meet with First Nations chiefs today as some turn to the courts to halt controversial national and provincial major projects legislation. Kate Kempton is the lawyer leading the challenge. She joins me live now with more on what is expected in the weeks ahead. So great to have you in studio with us. Thanks so much for making the time.
Thanks, Caryn.
I want to ask you about consultation and the issues around consultation, because parts of the federal law do provide for certain consultation up front. The governments, both governments, have been adamant that consultation will happen as projects are identified. Can you be specific on what provisions in these laws for consultation you feel are inadequate or perhaps being skipped?
Federally, we want the federal government to repeal Sections 6 and 22. It's not just the duty to consult means the duty to involve First Nations in the very decisions that affect their lands, and First Nations lands comprise all of Canada, and to participate in a meaningful way such that their concerns are addressed. And sometimes that means saying no to a project. So it's not just, throwing out the word consultation. It means participating in decision-making. The problem with both of these bills, Bill 5 is far worse than the federal bill, but the federal bill and the provincial bill have in common these sweeping absolute power provisions. And so they both say that the Cabinet has this sweeping, unrestrained authority to declare that certain other laws that would protect the environment, protect human rights, protect First Nations self-determination and other rights can be avoided and ignored when approving projects, massive projects and massive zones where a bunch of projects could occur. So we don't, if you've got that power on the one hand, which is opposite to including First Nations on the other hand, because you're wiping out the application of a bunch of laws that they would be involved in applying, then why should we believe that if what the law says you've got the opposite rights to do if you're the Crown government, why should we believe the Crown government that they're going to do the right thing when the laws that they just passed authorize the very opposite?
So does meaningful consultation to you look like basically wiping out that provision under both bills? Because it's my understanding, and please correct me if I'm wrong, that consultation, for instance, is not defined. There's nothing that says we need to talk for 6 months or a year. So what hinges on the federal government showing that it fully intends to engage with First Nations?
Well, again, it would be wiping out those provisions. Section 6 deems that projects that they want to approve are going to be approved. So right from the get-go, the whole engagement will be biased. The whole decision-making process will be biased toward approval. There won't be an option to say no by anybody. Section 22 is this absolute power corrupts absolutely provision that allows Cabinet to ignore the application of environmental assessment, environmental protection, human rights, and other laws. And so if you're engaging with First Nations, one would have to say about what? If you're removing the application of all these other laws, requirements, stipulations, and fact-gathering processes, what are you going to be talking to them about? There is a requirement in Canadian law that's been here for almost 3 decades that says that the Crown must consult with the intent to substantially address First Nations concerns, which means, again, that's always the requirement. So no, it doesn't say how many months. It depends on the facts. But it's always to bring them to the table to address concerns, to identify what those concerns are. So you need to know what the impacts will be, and then to work with the First Nations to address through prevention, mitigation, compensation, and other measures how to address those concerns. And if you're wiping out all those laws around which such consultation and engagement would happen, then there's not going to be much to engage, accommodate, and consult about.
Both governments have said that the laws are designed to address the frustrations around the processes in place to get projects approved. I wonder, is there a way for the governments to do both, to fully engage with First Nations, but also do the things that it wants to do with these bills and get things built faster in our country?
Yeah, the question we all have to ask ourselves is, build, baby, build, drill, baby, drill, at what cost? Are we going to throw out Canadian values which are embedded in the Constitution and which are the fundamental laws which guide a society in build projects? At what cost? Are we going to throw out the environment on which we all depend to build some projects? Anything done in haste and recklessly is dangerous, particularly in this day and age. And so, this is what we're against. We're not against economic development. Most First Nations are very much for it. They want a bigger role in it. Yes, we can do things faster and more streamlined. The bloated bureaucracy and red tape is within the federal and provincial governments. They need to fix those things because it's often First Nations who suffer the most delay and harm because of those bureaucratic quagmires and delays. We like them, less than anybody else does. First Nations have claims into federal and provincial governments for necessities of life, like housing, like affordable food, like drinking water that's actually drinkable. That those claims can get stuck in bureaucracies of the federal and provincial governments for decades. So we don't want that either. Including First Nations throughout the decision-making process is likely to be much faster.
Okay. I do have to leave it there. I'm unfortunately out of time. I do really appreciate your insight this morning and for making the time for the conversation. Thank you.
All right, thanks.